Good day, Observation Deck viewers. Well, I have seen and discussed the subject that is quite frankly a pain in the arse for so many people, both here in the UK and many other parts of the world. And that is parking charges from local authorities or tickets given by the police, etc., traffic violations in general. Now, I know many of you have bigger fish to fry, and worry not, because on that score I do have some great episodes in store to cover car loans, credit cards, and the one which hits many, which is mortgage foreclosures. And believe me, they will be dealt with sooner than you might think. In this episode, parking charges is an easy area to deal with, and if you pay close attention to what I'm going to share with you, you will realise the essence of what is being said reaches far beyond the subject of parking charges, and it really does, which is why I've picked parking charges for the episode, but that's for you to read between the lines and adapt this information to your individual circumstances. Now, let us see how we slam dunk those pesky local authorities or the police using nothing but the laws of our land, and point out some glaring inconsistencies with administrative claims which actually have no standing in law once you point them out to them. So with that being said, I'll see you on the other side. Hi, and welcome to this week's edition of the Observation Deck. Before I start, I want to make a quick announcement about upcoming shows that have been worked on in the background and continue to do so. You think, wouldn't it be great if we could talk to an expert, a licensed private detective who specialises in what is called chain of title violations within the loan markets, and who has expertise in UCC laws and who is recognised by the courts as an expert witness? Well, that one is on the cards, and very soon. And I think you would also like to know more about how to stop foreclosures, deal with student loans, or maybe even have a qualified expert at your beck and call just to make sure those documents you created are on point and powerful. Or maybe it would be better if your notices were sent on lawyers' letter-headed paper direct from your legal representative, one you could simply use to send your documents to keep your costs at a minimum. Well, over the next few weeks, I will be covering all that and more, as we have been busy in the background sorting out all that and the creation, literally, of a legal shield you can stand behind when claims come a-calling from banks to bailiffs. What is in store over the next few weeks and months will even allow you to take a home study course and become an honorary paralegal. Yes, you heard that correct. There is much more, but I think you get the point. And even the ability to repair your credit history is also included in all of this, and could allow those of you who take this particular journey to help others over the net and create your own home business. But I don't want to get too far ahead. I simply wanted to give you a heads up on things to come. So please stick with the Observation Deck, hit that like button, tell your friends about the OD, so more people can and will benefit from this and all other episodes, because it's going to get even better in 2021 for Remedy. Okay, let's discuss parking charges and pay close attention to the implications of what is being shared, since those details will and could have a profound effect on many other aspects of colour of law attempted enforcement, which is what I'm calling it. We start with a case that stretches back to 2013, and although it started as a simple challenge over a parking ticket, it soon went into revealing the colossal fraud of the modern so-called legal system, as you will see. For the remainder of this episode, I will be quoting from that case and, of course, inputting my own thoughts as we go, just to give you further hints as to what the other implications may be when dealing with similar matters. I will, of course, leave the full transcript of this case in the description below, and may I suggest you take careful note of every single word, the implications, and other types of claims made by unlawful corporate entities who wish to trespass against you. So let us begin. We start now with the case overview, and it is very important, the case overview, because it explains in detail all other types of claims that may be made against you. So let's start. And this is a bit of a preamble, but it's important, I think. What the government would like people to believe is that a procedural impropriety is an acceptable mistake that can be overlooked. But the truth is that this is a deliberate act of fraud and malfeasance in a public office. Now, before I go any further, I just want to halt it there for a second, because there are actually principles in public office, both here and in the United States. Before we go any further, I want to show you, because you can use those against these people that are trespassing you, because they weren't mentioned in this particular case. But let's just have a quick look at both of them and then we'll carry on. So in the UK, we've got called the 7 Principles of Public Office. They were all originally called I think it was the Noland Principles. But the 7 Principles of Public Life, it says here, also known as the Nolan Principle, apply to anyone who works as a public office holder. This includes all of those who are elected or appointed to public office nationally and locally, and all people appointed to work in the civil service, local governments, the police, courts, probation service, non-departmental public bodies, and in the health, education, social care services. All public office holders are both servants of the public and stewards of public resources. The stewards, not the owners. The principles also apply to all those in other sectors delivering public services. And they continue the 7 principles. Selflessness. Holders of public office should act solely in terms of the public interest. Integrity. I'm not going to read all of this because I'm going to leave a description below. But integrity. Yeah. Objectivity. Accountability, are accountable to the public for their decisions and actions and must submit themselves to the scrutiny necessary to ensure this, and by heck they are going to. Openness, honesty, and leadership. Honesty being an important one. Holders of public office should be truthful. Yeah, we'll come back to that in a second. Now, for those of my viewers over in the USA, fear not, because those are the 7 principles based here, as you can see, on the UK government's site here, and in the USA, Cornell Law School. Let me just bring in, now I know there's a cut off on the screen, so I do apologize. I haven't changed the screen size and I can't while I'm recording, but have a look. It's actually 5 CFR and then section 2635.101, basic obligations of public service, and it lists them, and I'm not going to read them all out to you either, because at the end of the day I'm going to leave a link in the description below. But a very interesting one is employers shall disclose waste, fraud, abuse and corruption to appropriate authorities, shall satisfy in good faith their obligations as citizens, including all just financial obligations, shall not use public office for private gain, etc, etc, etc. So it's very much like the Nolan Principles in the UK, but these have been enshrined into law over in the United States, basic obligations of public service. So you've got both of those, both in the UK, USA. Let's get back to the case, and I will leave the links to both of these in the description below, because they can be cited at a later date, should you wish to do so. Now let's jump back to the case in hand. So we were talking about a deliberate act of fraud and malfeasance in a public office. These are very serious crimes with criminal intent. The definition of fraud is a deliberate action to defraud where the victim of the crime is unaware, having no knowledge of a situation or fact. These crimes carries a penalty of 7 to 10 years incarceration, and the latter where there are multiple instances. So in the UK, 63.5 million people are subject to this crime every day on a multitude level, and is now commonplace and carried out by the largest and most ruthless criminal company in this country, which would be UK PLC. This same company is also a public office, which I've just explained on the Nolan and the USA principles, with the enforcement to execute this crime, which is inclusive but not limited to the office of the police, the office of the judiciary, local government, central government, independent bailiffs, debt collection companies. Please have a look at my book. Okay, Defusing the Debt Bomb. You can see it on the screen there, and move it away. Okay, companies are also licensed by the same company. Malfeasance or misfeasance or non-feasance are also very severe crimes with a period of incarceration of life imprisonment. Oh my God, you can. Malfeasance is a deliberate act with criminal intent to defraud, and ignorance is no defence. Can you imagine just putting malfeasance in there when you're dealing with a debt agency or someone else that's making a claim that's got no validation of said claim? Just throwing that in there, guys. Malfeasance has been defined by the appellate courts in other jurisdictions as a wrongful act which the actor has no legal right to do. There'd be your debt agencies as well. An act for which there is no authority or warrant of law. That could be most of them. An act which is a person ought not to do. That would be everybody trespassing against you. An act which is wholly wrongful and unlawful, that which an officer has no authority to do and is positively wrong or unlawful, and as the unjust performance of some act which the party performing has no legal right, which, to be honest with you, if they haven't got a validation of claim, as we will see just on the parking charge, but remember, debt collection agencies and even banks pull this crap on a regular basis, but we'll get to that. Crimes of this nature cannot go unpunished. If a crime goes unpunished, then the criminal will undertake the action again and again. When the criminal is rewarded for the crimes by their peers and superiors, it becomes difficult to know that a crime has been committed in the first place. However, it is everyone's obligation to be fully conversant with their actions and the consequences of their actions in every situation, which is one of the reasons that we put notice to agent is notice to principal, and notice to principal is notice to agent. I suggest you Google the term vicarious liability. Then you'll fully understand why we put notice to agent, principal, etc. Vicarious liability. There's a good one for you, folks. Go search for it. So that phrase, I was just following orders, or I was just doing my job, is no excuse, as you could all remember at the Nuremberg trials. When the full extent of these crimes is realised, it then becomes blatantly obvious that these crimes are deliberate and in full knowledge, if not by the lower subordinates, but definitely by the executive officers of the company. Remember the principles of public office. The cost to us victims of these crimes has been estimated in the region of 4,037.25 trillion over the past 35 years. This is the cost of the people of this small country. We're talking about the United Kingdom here. Can you imagine what it is in the USA, folks? Oh my God. Which is far in excess of many times the global GDP. The simplicity of this case is very often overlooked, as it involves a simple parking charge notice or penalty charge notice, which is what I was saying at the beginning, folks. Just because this is about a parking charge, you'll understand as I move through this. It is important to note here that the appellant at the tribunal did not challenge the parking charge notice or the Traffic Management Act 2004. What the appellant did was to remove from jurisdiction the very foundation to any claim made under any act or statute of Parliament, all of which have the same legal dependency that has never been fulfilled for nearly 800 years. And I will explain this as we go along. There are in excess of 8 million acts and statutes in this country alone, and it's estimated that around 8,000 pieces of legislation are written and implemented every year. I mean, you can often tell the corruption in a society by the number of acts, laws and statutes that it creates, so it speaks for itself. And the point being is, none of these can be acted upon without legal authority to do so. To act upon these acts and statutes without the legal authority to do so is malfeasance in a public office and fraud at the very least. This case was undertaken at a tribunal and therefore became a valid, recognised due process that undeniably confirms this to be the facts of the matter. All right, so it's there. So the case, now remember, it's not just about the parking ticket, but we're using that as a platform to explain a lot deeper stuff here. This may appear to the reader by simply a penalty charge notice, but closer observation of the details will conclusively show otherwise. This is the notice that was sent by Warrington Borough Council, and it clearly shows a claim being made against the appellant's motorised road vehicle under the Road Traffic Act 2004, and is clearly no disclosure to the fact that there is no liability to pay, as the outcome will show. You are not liable to pay for this ticket. Now these are very familiar to many of us, and as you can see, the next document is physical evidence, and you should keep all of your physical evidence as exhibit A, B and C when you do your proof of validation of claim against these trespassers. But the next document is a physical evidence of notice to owner. So remember, this isn't a letter, they're sending you a notice, and we're going to be doing the same, of April 13. It also quite clearly marks the claim on the 5th of March. There had been a violation of the Traffic Management Act. So it's quoting this ticket here. Now, the next bit is the representations, which most people tend to forget. But along with the opportunity to make representations as to why there is no liability. So they're giving you the opportunity for you to actually say, why do you, the traveller, not have liability? And the reason that they have to put this, well, let's read it and see. Please note that this is an unsigned notice and therefore is not a legal document. Would you like me to repeat that for all of you people that have been given such a notice? It is unsigned, therefore it's not a legal document. Hint, hint. The mitigating circumstances are that there has been a procedural impropriety, which is clearly an option, as is clearly stated on the notice owner, third box from the bottom. Okay, so the owner has ticked this box. There has been a procedural impropriety by the enforcement authority. And then it goes on to say, please complete section 3. To be honest with you, you can complete your whole A4 sheet of paper, because they never give you enough room in section 3 anyway. So it is apparent that there is a deliberate procedural impropriety in place with the full knowledge of the Borough Council. Otherwise, this option here wouldn't be part of the notice to owner. But it's like we've said before, I've said it on my channel, and I know that, I know Gumshoe said it on his channel, and loads of other people have, and that's basically, look, if you don't know what your remedy is, then you don't have a remedy. And if you don't know your standing in law, then you're basically lost. You don't have any standing. So they put these in there, and you should take notice of them. All right, so it's apparent there's deliberate impropriety, otherwise that wouldn't be there. We also took the opportunity to utilise a second option that confirms that there is a procedural impropriety. Okay, and that the order which is alleged to have been contravened in relation to the vehicle is invalid, second box from the bottom. In other words, the order which is alleged to have been contravened in relation to the vehicle concerned is invalid. All right, so you tick both of those boxes, and we'll explain why it's invalid and why you can use it for many other things. So that, again, if not, then why would these possibilities be on this notice to owner if a procedural impropriety were not a possibility? So, in this case, we took the opportunity to complete section 3 of the notice to owner to clarify the procedural impropriety on a separate sheet of paper as advocated by the council, because there was not enough space in the notice to owner provided. And remember, the owner, if you're a vehicle, at least ways in the UK is DVLC. So they didn't even send it to the correct address, did they? You are the keeper, you're not the owner. Sneaky swines, aren't they? But here was the letter that was sent, okay, back to Warrington Council. So it starts, Notice of opportunity to withdraw. Notice to agent is notice to principal, as I've explained already. Do not ignore this letter. Ignoring this letter will have legal consequences. Your reference, which would be their ticket number. Dear sirs, and I suggest that for those of you who are going through this at the moment, and there is a couple on my Telegram group, you know who you are, and I did promise you that I would upload this Friday, so there you go, Nick. Dear sirs, we do not know to whom to name as the recipient of this communication, as the sender failed in his or her duty of care and did not sign the document sent to Mr. David Ward at his address. The action of not signing the document sent to Mr. David Ward legally means that no living person has taken legal responsibility for the content of the document on behalf of the council, and the document couldn't legally be responded to. That very act of not signing the document renders the document void, and therefore non-legal and unusable in law under current legislation. Strike 1. Deliberate deception. This document will now be kept on file as physical, presentable evidence, that will be your Exhibit A or B, as it represents the criminal activities of the representative of Warrington Council, whether they are aware of this transgression or not. Ignorance of the law is no defence, and all of the representatives of the council are now culpable under the current legislation because one individual failed to sign the document. This is a fact and must be understood. Strike 2. Ignorance of current legislation. The third grave error on the document is that the document is a notice to owner. Well, I've already mentioned that. Under the current legislation, the owner of any motorised vehicle is DVLA Swansea. This means that some imbecile at the council has sent a notice to the owner to the registered keeper and not the official owner. Strike 3. Document sent to the wrong address. We have not progressed beyond this first line yet. We are falling around on the floor in a state of hysteria at the incompetent levels demonstrated by the representatives of the council. Mr. David Ward is the official registered keeper and not the owner. The very next line refers to the Traffic Management Act 2004. Now this is where events become really interesting, because the act referred to is actually an act of Her Majesty's Parliament and Government PLC, a recognised unlimited corporation or an all-for-profit business. An act which is not law in the UK. It is not even referred to as law, as it is an act of a corporation or an all-for-profit business or policy, but it is not law. Strike 4. Displays lack of understanding and competence regarding what is the difference between law and legislation. Acts and statutes of Her Majesty's Parliament and Government PLC can only be given force of law by the consent of the governed, by those who have agreed to acts and statutes of Her Majesty's Parliament and Government PLC. Therefore, there is a mandatory legal requirement under current legislation that the governed, that would be me and you, must have given their consent legally, which can be physically presented as a fact before the acts and statutes of Her Majesty's Parliament and Government's PLC can be given force of law. Please, people, even that single paragraph, acts and statutes, from that point onwards there, anyone coming at you with a claim, you might want to remind them. I told you there was a lot more in here than just talking about parking tickets, because now we can cover acts, statutes and legislations and the consent of the government governed, and they must physically present the actual agreement. No contract, no claim. Are you getting this, folks? So therefore, not law, not enforceable, and 6.35 million people in the UK have not legally entered into those agreements, 8 million plus, in full knowledge and understanding of their own free will. So therefore, there is no contract. An agreement which must be kept on the public record for the acts and statutes of Her Majesty's Parliament and Government's PLC to be given an action which involves force or the force of law. The answers to the questions are in the understanding of the words used to implement the act of force or law. The next item we come is a demand for payment. This is part and parcel again of the ticket. A demand for payment without a signed bill is a direct contravention of the Bills of Exchange Act 1882. Strike 5. Jesus Christ, you normally only get 3. The Bills of Exchange Act 1882 is based upon pre-existing commercial contract and or agreement. And if you don't know where it is, well, when you download this, you can see the Bills of Exchange Act 1882, and all Commonwealth countries, nations, have a Bills of Exchange Act. It might not be 1882, but it's the same Act. It's just it was introduced slightly differently. I think the first one was in India, then it came to the UK, Australia, USA. So you've all got it, so you can find your own. Profiteering through deception is an act of fraud. Strike 6. See Fraud Act 2006 in the UK, and you can see the Fraud Act if you've bought my book Diffusing the Debt Bomb in the USA, because it's listed in there, and then you've got the link to the government. All right, so the point is that a demand for payment without a signed bill is a direct contravention of the Bills of Exchange Act. Did you get a signed bill when they gave you a ticket? Or, in fact, did you get a signed bill from anybody making a financial claim against you? Like, I don't know, a debt collection agencies? Of course you didn't. Insisting or demanding payment without pre-existing commercial arrangements, which is based on presentable fact in form of a commercial agreement, is an act of deception. Payment is a commercial activity. This is talking about court of equity, in which case then the administrative courts simply have no jurisdiction right from the get-go. So, you have been served legal notice. Mr. David Ward has no recognisable legal means to respond to a demand for payment without a signed bill under the Bills of Exchange Act, which is based upon a pre-existing commercial contract or arrangement or agreement, simply because, and he goes on to say, no standing commercial contract or arrangement or agreement between Mr. Ward and the council exists. Show me the contract. If Mr. Ward was willing to comply with the demand for payment without a commercially recognised bill, then Mr. Ward would have knowingly given consent and conspired to commercially fraudulent actions. And we certainly don't want to do that, people. So we need a wet signature bill, in which case then someone in the council is going to take full commercial liability upon penalty of perjury. This in turn would make Mr. Ward culpable under the current regulation for that action. Mr. Ward will not knowingly create that liability against him or create that culpability. Of course we wouldn't. Well done, Mr. Ward. And neither would the rest of us be forced into breaking any laws. The very presentation of the document that we are responding to from the council, which is also a document that will be kept on file for future presentation as physical evidence, exhibit number, which is presentable physical evidence and the list of transgressions against the currently held legislation. This same document supplied by the council recognises that there may be, or has been, a procedural impropriety by the enforcement authority. Underlined, this is the only saving grace on this document, which allows for an honourable withdrawal, hence the withdrawal notice, of the proceedings implemented illegally by the enforcement authority. This document is a representation as to the procedural impropriety by the enforcement authority, and, as stated at the outset of the document, gives an opportunity to these people to withdraw due to the procedural impropriety by the enforcement authority. This process is also a matter of complying with current legislation, without which Mr. Ward would be unsuccessful if he were to pursue legal proceedings against the authority and all the members of the council. As the opportunity to withdraw has now been presented to the enforcement authority and members of the council under a procedural impropriety by the enforcement authority, should the above mentioned not take the opportunity to make an honourable withdrawal and confirm such in writing to Mr. Ward, then Mr. Ward will be left with no other option in future but to start legal proceedings against said authority and the members of the council. Remember, you can slap a commercial lien once you've dealt with these people yourself, because they attacked you without a valid claim. That's a tort, people, and they committed fraud and attempted to get monies with malice by threatening taking you to court and all sorts of other things. Boy, have you got a case. The content of this document will be in the public domain in the next few days, as there is no agreement in place that is legally binding of which to prevent this. Yep, make it a public notice. Mr. Ward does not expect to be hearing from the enforcement authority or the members of the council again unless it's in the form of a written confirmation of withdrawal proceedings. No further correspondence will be entered into regarding this matter without prejudice, i.e. all natural and unalienable rights reserved for and behalf of Mr. Ward. Mr. Ward reserves the right to use force to defend himself, his family and his home, which is unlimited right to do so. It's called the Castle Doctrine, and I've got a friend who really likes that, and you know who you are. Response to this notice should be forwarded within 10 days of receipt of this notice to the postal address known as, right, I would put brackets in the postcode, but that's entirely up to you. No assured value, no liability, no errors and omissions accepted, all rights reserved, without recourse, non-assumptive. You have been served. All right. Now, the council sent this letter back, and I'm going to increase it so you can actually see. And this was in response to what I've just read out for you. And you can quite clearly see here that they have no idea what they're really doing. Okay, notice of rejection. Okay, so they're rejecting the representations even though it's actually enshrined in law. Idiots. Your representations against the above penalty charge notice have been carefully considered, clearly it hadn't, in the light of the circumstances at the time and in accordance with the Traffic Management Act 2004. Grounds for cancellation of this charge have not been established, and this letter is the formal notice of rejection of representations. Don't worry, people. The reasons for rejections are your vehicle was parked in a designated disabled parking place without displaying a valid department. Right, so now let me just give you an update on this pathetic reply before we go on any further. All right, the point being is they did not rebut point for point any of the reasons for the rejection on that notice. All right, they didn't rebut a damn thing. So therefore, if they're going to fall straight back on the Road Traffic Management Act 2004 and not rebut anything that else was said, then it becomes truth in law. Slam dunk, you lose, Mr. Council. But let's move on. So let's have a look. There is no effective... Sorry, let me just bring that back down so you can see it. Right, there is no effective contest to the presumptions made. So the presentations previously made in the correspondence stand as fact. Like I've just said, it's unrebutted, so it stands as truth, stands as fact. At this point, the council invited Ward to take him counsel to a tribunal, and the outcome would be legally binding on both parties. So we took advantage of this generous offer, and we included a copy of all documents up to this point as physical evidence, exhibit A, B, C and D, etc., as I've told you before in my previous books. This was the same process as before, with the same presentation to council, accompanied by a letter to the adjudicator as follows. I love this. Please forgive the informality, as we've not been made aware of the name of the adjudicator to whom I addressed the letter. Always stand in honour, people. This is in response to the council's decision to reject my challenge against the parking charge notice. Clearly, the PNC has been challenged by Mr. Ward. However, that challenge has never been rebutted by the council because they can't, and have only repeated the grounds under which the PNC was raised. Copy under same cover that is highlighted. So he's talking about the areas that have been highlighted here. Okay, that is highlighted. Now, copy under same is highlighted. Also, PNC is a penalty charge notice, and as such, a notice of a penalty charge. A recognisable bill has not been raised and presented to Mr. Ward, complete and finalised with a wet ink signature. As the presentation made by Ward were not addressed, then the challenge made by Mr. Ward still stands and the PNC is not valid or enforceable. Warrington Council has made a demand for payment but has not yet presented Mr. Ward with a bill, remember, Bills of Exchange Act, which is recognised under the Bills of Exchange 1882, and we must have a signature in wet ink. Warrington Council cannot raise a bill because there is no commercial arrangement in place between the council and Mr. Ward under which a true bill can be raised. How many people will that paragraph be applicable to. And remember, folks, we're not just talking parking tickets here. Please read between the lines here. Okay, anybody sends you a claim for any money, is it a true wet ink signature bill, or is it one of those templates that DCAs tend to use to scare you into paying them money that they probably, on many occasions, actually have no claim to? Just remember that. I mean, that's just the Bills of Exchange Act, let alone the fraud and everything else. For Mr. Ward to respond by paying a bill without a signed wet ink, then that would be a direct violation of the Bills of Exchange. In addition to this, there is no commercial arrangement, and the bill presented then would also be a contravention of the Fraud Act. How many organisations would this same thing apply to? Screw your heads on, people. Mr. Ward was not in the habit of knowingly conspiring to fraud. Absolutely not, Mr. Ward. Well done, sir. This action would also create a liability against Mr. Ward. We always stand in honour. Clearly, the people we're having to deal with do not. The council also listed their rejection of presentations as the Traffic Management Act. It's not even a law, folks, remember? In support of their claim. The acts and statutes of Her Majesty's Parliament and Governments PLC can only be given force of law by consent of the governed. Please, people, no matter where you are, what you're doing, only be given the force of law. An act can only become a law by your consent. And you're not going to do that, are you? What is mandatory in the first instance is the consent of the governed that is also presentable as a fact. In other words, show me the agreement that I have with you, the contractual agreement with my wet ink signature, which they don't have. As the consent of the governed is not presentable as a fact, as I've just explained, then the acts and statutes of HM Parliaments and Government PLC cannot be acted upon in any way that would cause loss to the governed. Now, people, please, did you notice that the coronavirus 2020 is an act? And everything that stems off the coronavirus, masks, lockdowns, social distancing, walking, I don't know, how about walking into supermarkets? And it doesn't necessarily have to be in the UK either, USA. Walking into supermarkets and saying, you know, you can't come in there unless you've got a mask on, which we know is also discrimination. But the very act itself, the Coronavirus Act 2020, comes into play here. People, please read between the lines. Okay, consent of the governed. So what is mandatory in this instance is the presentable agreements of all of us governed to be in place before an act or statute can be acted upon. All right, it's mandatory. We fail to see how this is in support of the PNC presented to Mr. David Ward. Now, can you please understand, people, why I said this goes way beyond a parking ticket? We fail to see how listing the Road Management Traffic Act supports the claims made by the council in any way other than to create obfuscation in attempt to confuse the mind. Yeah, they're basically bullshitting you, like debt collection agencies do. Strangely enough, the debt collection agencies that I've been working with over the last couple of months for some very close friends of mine have gone awfully quiet, and with no threats as well. Interesting. Anyway, there are no arrangements in place to the 220,000 residents of the Borough Council, excuse my little dog barking out there, which can be presented as facts complete with signatures on wet ink, which can be presented to support the claim of the council in support of a demand for payment. All right, there are no agreements, and we're not just talking about this particular act, we're talking about the Coronavirus Act and everything within it as well. Wakey, people. And it continues that without violating the Bills of Exchange Act of 1882 and the Fraud Act of 2006, Section 2, fraud by false representation, you just have to see this link here. All right, and you can read that in the obviously in this document's description. But this applies to so many other things, the wet ink signature and a true bill. If they're not prepared to do that, they have no claim. Are you getting this, folks? I'm sure you are by now. All right, but that on its own will bat off most claims, including debt collection agencies, I hasten to add. A person may be regarded as having abused his position, remember public office, even though his conduct consists of an omission rather than an act. In other words, they're not telling you. So see again, legislation, government, 2006-35, section 4. An omission in the form of an omitted signature would constitute an act of fraud under S4, S2 of the Fraud Act 2006. Just go check the bottom of all of those claims that you're getting and see if they've had the balls to actually put their wet ink signature. I doubt whether they have. I've got loads of those examples and nobody was willing to sign them. So there you go. So let us summarise regarding the grounds for an appeal with reference to the form provided for the appeal. Number 1, the allegation contravention did not occur. We're talking about the traffic contravention here. No contravention has occurred because there was no agreement between the 22,000 members of the council which can be legally presented as a fact in support of that contravention. Oh dear, and that obviously includes all councils. 2. There has been procedural impropriety by the council. The council did not respond to the challenge made by Mr. Ward in a manner which would make any sense or would constitute a rebuttal point for point to the challenges that he made. The council are advocating to Mr. Ward in their demand for payment without a bill presented, a direct contravention of the Bills of Exchange and the Fraud Act 2006, because there's no signature as well. Number 3, the traffic order that is alleged to have been contravened in relation to the vehicle concerned is absolutely invalid. The traffic order, that's a new approach, unfortunately it's not possible to find a listing for that, is illegal because there is no agreement between the parties which is legally presentable as fact and signed in wet ink. You have got to love that word legal. Legally blind legal consent, all presentable as fact complete with signature in wet ink, and without that signature in wet ink on a legal document in the form of an agreement, then it is not legal or is illegal and therefore not lawful. You got to love the word legal. Need we continue? It is obvious at this point that there is no one at the council that is capable of understanding the challenge made by Mr. Ward or capable of responding. Therefore, an adjudicator becomes necessary. Remember, this is part of the letter to the adjudicator. There is only one outcome to this tribunal, where the adjudicator is a recognised lawyer and is independent of the council. The challenge has been made and has not been effectively rebutted by the council. The action of demanding payment without the presentation of a lawful legal bill, which is subject to the Bills of Exchange Act and signed in wet ink, cannot be responded to in the manner expected by the council without a second transgression against the Fraud Act 2006. Regardless of the legislation or policies of the Council or Her Majesty's Parliament's PLC, any commercial activity would constitute an act of fraud without the commercial agreements in place beforehand. People, take note, without the commercial agreements in place beforehand. If you've been given a bill, if you've been given an on-the-spot fine or anything like that for whatever reasons, or because let's face it, PNC is an on-the-spot fine. It's just that you don't normally see the asshole delivering it, but so there's no commercial agreements in place. All right, the continued activities where demands for payment are made without observing the Bills of Exchange Act 1882, a recognised bill is presented complete with wet ink signature is continued a procedural impropriety by the council, and members of the council are culpable in law for their actions. There can only be one outcome to this tribunal, which is acceptable under current legislation. The council will find in favour of the appellant, Mr. Ward, and not in favour of the continued transgressions against current legislation of that outcome. In the documents provided outlining procedure to make presentations in this tribunal process, there is a section concerning costs in favour of the appellant where the party has behaved wholly unreasonable. We have taken a considerable amount of time and energy responding to the council when making representations in preparation for this tribunal. It is not without reason that consideration could be expected. Ooh, look at that, see? We're going for a claim, we're going for a lien. Equitable consideration for our time. This would also serve to enforce the decision made by the adjudicator at this tribunal. If the adjudicator is truly independent and an honourable individual, then a consideration is in order. Absolutely. Mr. Ward also notes that as this tribunal is informal, then it is also recognised as not legally binding, regardless of the findings of the adjudicator. You see, the council tell you it's legally binding, but it's not because it's informal. There you go. We would also like a response in writing from the adjudicator to relay the outcome of this tribunal, conveying the reasons for the adjudicator's decision. In other words, you're going to have to put your wet ink signature on, and if you actually find in favour of the council, knowing that they have actually breached the law, then you're in trouble, mate. Without prejudice, blah, 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 non-assumptive, etc., etc. Now, the bottom line here is that the results from the tribunal as follows. Decision, cover letter, and here we go. Enclosed you will find a decision. A copy has been sent to the council. Attached notes explained. If payment is required, please send payment to the council, not to the traffic penalty tribunal, blah, blah. Clearly, this is a tribunal as such as recognised due process, which legal and binding on both parties. In addition, there was an adjudicator's decision. Well, if it was informal, then it's not legally binding. But here's the decision. Appeal allowed on the grounds that the council does not contest the appeal. I'm sorry. So it was issued on the 5th of March in Cairo Street, blah, 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 and blah. The council has decided not to contest this appeal. The adjudicator is therefore directed the appeal is allowed without consideration of evidence. In other words, they did. Now, this is what happens quite often. Without consideration of evidence or the merits of the case, the appellant is not liable to pay an outstanding penalty charge. Right now, the reason, just let me explain this to you if you don't know, is allowed without consideration of any evidence. The last thing they want is that evidence that we've already covered to be put on a court of record to prove to every single person in this land that they don't have a leg to stand on. And this does not just apply to parking charges. This applies to every act, legislation and statute that is not law. All right, which is why they thought, oh no, we can't have that. All right, so that's why they're just hiding the fact that they don't have a leg to stand on, and they don't want the rest of the world to know. And hopefully now, if you share this video, the rest of the world will. Now let me just finish off with what this chap had to say. Appeal allowed on the grounds the council does not contest the appeal and it's not decided. Right, so the council cannot, and this is what I was saying, they cannot contest the appeal. There is a mandatory requirement for the council to present as physical evidence and factual foundation for the claim, which is the legally signed on and for public record consent of the governed. Please. There's your Coronavirus Act BS coming out here as well. Told you it wasn't just about parking tickets. This is the legal authority that the council would have to present as physical evidence and foundation for their claim to allow this claim to have any legal substance in presentable facts. So for all of those who have got your masks and whatever other penalty charge notices that you've been given for whatever reasons under the Coronavirus Act and God knows what else, all right, where is the consent of the governed? Because it will be required as physical evidence. He who makes the claim must provide the foundation and the physical proof or evidence in substance of that claim. Otherwise, well, as he says here, the moon could be made from cream cheese, and just because the council says so, then it would be. Exactly. Without this physical evidence, then the claim is fraudulent, and so are your spot charges, guys. Hence, a crime is committed by the council, and that crime is fraud and not procedural impropriety or mistake. Fraud, remember? So someone has brought a tort against you. Now, personally, if it was me, and those of you who've bought my book, you know that the fourth protocol, it's like, yeah, okay, I understand that now that I've got you, you're not coming after me for that claim, but now I'm coming back after you for making it in the first place, because that is a tort and I'm going to get you. Now, so the fraud is not procedural impropriety or a mistake. No, it's plain fraud. Also, there is a second crime. The second crime is malfeasance in a public office. Remember the 7 principles, the Nolan principles, and the USA versions. A clear and intended action to extort funds where there is no legal authority to do so. All right, that is a criminal charge. Again, they wouldn't want that in a court of record, so I can guarantee you when you slap a lien on their public liability insurance, if you're going for the council as a whole, or you want to pick the head of the council and slap a lien against his property, whatever that may be, that will make them look up. Yes, I have done it myself and won on previous occasions, many years ago, but it was fun. The adjudicator has therefore directed that the appeal is allowed without consideration of any evidence or the merits of the case, and that's because they cannot produce, the council, their own evidence, given what I've just told you, but they don't want us, the people, the governed, without the consent of the governed, remember, they don't want that in a court of record because we've got all the evidence to the contrary, and that's the last thing that this fraudulent system house of cards wants. So, clearly there are merits of the case that have been presented here. The appellant is not liable to pay. There is also confirmation of the fact that the council and a signed wet ink by an officer of the state, Scott Clark, so they've actually done it this time, which is notice of appeal not contested by the enforcement authority. They don't mind signing that one, saying we're not going to appeal, but they certainly wouldn't sign the original one. So, due to the unanticipated, this is what they wrote, by the way, this is the council. Due to the unanticipated shortage of parking services staff, the council has no alternative except to exercise our discretion and cancel the above penalty charge notice. This is a very interesting choice of words, as this letter writer says, because they obfuscate deliberately in nature. The council will never be able to provide staff which can provide the legal consent of the governed because of the past 800 years the governed have never once been so much as asked to provide the legal consent of the governed on and for the public record. So the council or its parking services staff cannot provide something that does not exist and is of no physical substance for the foundation of any and all of their claims, which is why they've come out with this BS here. All right, we have exercised our discretion. Yeah, I know you have, because you're running like scared chickens. The council has no alternative to except to exercise their discretion, as there is no legal consent of the governed, and the council does not have any authority or discretion to exercise. And this also applies, remember, to HM, Her Majesty's Parliament's Government PLC and parent company. So, in summary, and I know this has been a bit of a long episode, guys, but I'm sure you've got a lot from it. It is apparent that the ramifications of this case authority are huge and not transparent at first glance, although I hope I've given you some hints as we've gone through. But consider the following. A license is a permission to undertake an action that would otherwise be illegal. Okay? It's not HP, it's HM. Governments and parliaments and PLC clearly do not have the legal authority to issue any form of license without the legal and physically presentable signed in wet ink consent of the governed. Doesn't matter whether it's a parking ticket or it's something that some person is dished out wearing a revenue collector's uniform with the word police on it. Also, Parliaments and Government PLC do not have the legal authority to determine that an action is illegal without the legal and signed consent of the governed physically on or for the public record. This is huge, guys, and I hope you stand your ground on this. There is no physical record of the fact that all of us have not signed the consent of the governed. 63.5 million people have never once been asked or have never once signed the consent of the governed. As the office of Parliament is only a 4-year term of office, there must be this signed legal document every 4 years on and for the public record, which clearly isn't. All forms of tax, VAT, duty, council tax, etc. is illegal and constitutes fraud and malfeasance in a public office without this legal dependency being fulfilled. Guys, we're not just talking coronavirus. We're not just talking parking tickets. I hope you're getting this now. Okay? All forms of tax, value-added tax, duty, council tax, under the same rules that you will find in this document. If you care to cut, copy and paste it correctly, you will find that it is applicable. The enforcement of these acts and statutes by the police, the local authority, the judiciary and government licensed bailiffs are also illegal and constitutes malfeasance without this legal authority to do so. And if you've got, I don't know, an affidavit already fired up and ready to go, or you're in the process of creating one because of circumstances you're currently in, I suggest you do so. Make sure you send it special delivery and track that thing. All right, before any case comes to you, and then you can get them to rebut the questions or the affidavit itself. If they can't, no case. It is a known fact that it has been documented by chartered accountants that the populace pay all manner of tax to the tune of around 85% in the pound. So if you were to say, for instance, your wages, your salary will be taxed, then what you buy is taxed on VAT and your petrol and all the rest of it, 85%. We get 15% what's left, that's what we call liquid assets. How ridiculous is that? Sometimes where fuel is concerned, at least ways here in the UK, 92% of a fuel price is tax. 92%. So only 8% of what you're paying at the pump is the actual cost of the fuel going into your vehicle. The argument has been made that it is necessary to pay tax for the services that we need, such as police, ambulance service and so on. Then it should also be argued that these people who provide these services should not pay any form of tax because they've been paying via tax, but they should live a tax-free life. Obviously, this is not evidence in fact, and the contrary is true. Even the taxpayers that pay the taxes get taxed. It would also be accurate to argue that 15% of the populace actually gets to keep what they pay for all the services inclusive. The people provide services, not the government. This would be an accurate assessment of the available facts. There is no valid reason to pay tax at all, and the cost of living would drop by 85% minimum, because that's how much the cost of living would drop if we were stopped being taxed to the tune of 85%. So you can see the massive financial fraud by all of these blood-sucking leeches. So you just do the maths. All public office officials are also victims of this crime, including the police, ambulance, paramedic, teachers and so on. In fact, there is not an instance where there is not a victim of said crime. None of us. Absolutely none of us. The ramifications span well beyond the contents of this case authority undertaken by a recognised due process tribunal. So folks, let me just wrap up this episode, but I hope you've learned a lot. And as I said right at the beginning, this is not about just a parking ticket. This goes way beyond that, and I just want you to do your due diligence on the details of these documents so you can stand your ground. Let me finish off with a summation. Well, there you have it. Not so much a detailed look at a simple parking ticket, but the basis for dismantling any and all invalid claims. It will be your ability to recognise and cherry pick the appropriate areas, your due diligence, which will allow you to adapt this single document to many situations and create your own affidavit to be rebutted. Which of course, without consent of you and I, the governed, and the omission of a true bill signed by wet ink signature, those who are making any claims cannot provide you with either of those and the evidence they need to enforce their invalid claim against you. So it's a win-win for us twice. Add this to my books, The Lean Machine and Diffusing the Debt Bomb, and you have at your disposal a lawful shield which will be impenetrable. Now that is worth your time and effort, don't you think? As I stated at the start of this episode, I will be covering even deeper the aspects of remedy and helping you deal with things like foreclosures, loans, and again for those interested in becoming educated on how to win any court hearing should you wish to do so. And yes, that includes compelling a judge to act on your behalf. All this is to come, and I can assure you a whole lot more. So please share, like, subscribe, and go grab my books. They will help you become the lawful warrior you were always meant to be. Until next time, question everything, believe nothing, and stay curious. And I'll see you on deck very soon.